Hearing in the appeal, Stocker against Stocker.
Yes, Mr. Price.
May it please the Court, in this appeal I appear with Jonathan Price for the appellant, and my learned friends Manuel Barker, Queen's Counsel, and Claire Overman appear for the respondent. This appeal raises interesting and important issues of law for defamation claims, but at its heart it concerns the meaning of 4 words, tried to strangle me, in context. I submit that permission to appeal having been granted, my client has the right to invite this court to make an independent determination of the single right meaning of those words in context, the Court of Appeal having declined to do so. Before I get to the legal route that takes the court to this point, I would like to make clear what my client's submissions are on the right meaning of those words in context, because it is often the case that detailed arguments on the technicalities of defamation law can obscure rather than clarify this core issue. It is summarised in paragraph 1 of the appellant's case on page 48, tab E for those with working from the hard copy bundles. It's the second sentence. The phrase tried to strangle is a common way of describing an assault involving a constriction of the neck or throat where the victim is alive. An unqualified allegation of strangulation is rarely made in such circumstances. The phrase does not convey an intent to kill in ordinary language or in relevant criminal offences. Insofar as this point needs amplification, it can be found set out briefly in paragraphs 62 to 66 on page 62. Which I'll just read out because it's fairly brief. Strangling is a well-known form of domestic abuse.
You don't need to read us out.
Well,
We have read it.
I'm most grateful. So it's down to 66.
Yes. So from paragraph 64, is the implication of paragraph 64 that the words meant he violently constricted my neck or throat in a way which prevented me from breathing? What comes to mind?
That was really how it was, as it was put by Lady Justice Arden, as she then was when granting permission to appeal. It's an act of choking that ceases prior to death.
The way you put it, I think, in your defence is they impute a gripping of the neck which inhibits breathing,
yes,
so as to put the woman in fear of possible
yes,
killing. Is that something you stand by still?
Yes. I mean,
You said there's no difference.
but once your neck is being, any constriction of the neck is going to make it hard for you to breathe, and it's going to lead a person to at least fear for their life. I mean, cutting to the chase, once a judge found that in temper, the respondent had put his hand on the appellant's neck with such force that reddening was visible 2 hours later. And that's the end of the case, really, as far as any chance that the respondent has got of succeeding in a libel claim.
What's the significance of the words tried to?
Yes, well, if what's being suggested is try to necessarily means try to and failed to, I wouldn't accept that. I mean, if we're talking about as a matter of logic, as opposed to how words would have been understood by the parties to this Facebook communication, anyone else who was reading it, tried to can describe an act.
Describe what?
An act. It doesn't have to involve a mental state. If you look at the relevant criminal offences, they have an attempt, which we can equate with try to, and then an intent. So that it's not necessarily the case that tried to involves making a statement as to the mental state of the person who is committing the act, even as a matter of logic. And if one goes to the judge's analysis of a primary meaning of strangle being to kill by strangulation, then you would never actually describe it in that way if someone was alive. He strangled her, or I mean, obviously if it's he strangled me and someone's saying that, then they're alive, so there hasn't been a killing. But the primary definition as relied on by the judge could apply in circumstances where it's a third person describing something, such as he strangled her. And if the person is alive, the victim of this assault, then if that's the primary meaning, we shouldn't be using that description at all. And what the judge is effectively saying, if you go to the words complained of, that the appellant should have said, he strangled me, and that would have been less serious than saying he tried to strangle me. But on the point of logic, I submit that try to does not impute a mental state as a matter of logic.
A matter of logic or a matter of ordinary usage?
Ordinary usage. And here we're using the words tried to strangle in a woman who's describing an act of domestic violence. And in my submission, that ordinary people know enough about these sorts of descriptions to know that that is not imputing a state of mind of an intent to kill to the perpetrator of that act. That's not how the criminal statutes approach it. And we have to deal with the real world. This is not an indictment. This is a Facebook conversation describing acts that have been perpetrated by the respondent on the appellant. That's why I say in paragraph 64, the ordinary reader is not focused on establishing the precise mental state of the aggressor. I mean, what's relevant is the nature of the act, and the words try to strangle describe an act. Don't impute an intent. The try to is that it didn't result in the conclusion. It's an act which, if carried through to its conclusion, would have resulted in death, but didn't because it stopped.
Well, what's the difference between tried to kill me by strangling or tried to strangle me?
Well, tried to kill me by strangling emphasizes that he was trying to kill her. Whereas,
Well, would an ordinary reader make a distinction between those two statements?
well, yes, because there's an explicit assertion of a try to kill.
Yes, but the means of killing is strangulation. Tried to kill me by strangling me.
Well,
And if you use a shorthand version, tried to strangle me, would the ordinary reader distinguish between those two situations?
the ordinary reader isn't faced with having to make a distinction between two situations. The ordinary reader is being faced with some words and what those words mean. But yes, I do submit, in answer to the specific question, that an ordinary reader would distinguish between those two situations, because in the first situation, there's an explicit allegation of an attempt or intent to murder, and in the second situation, there is simply a description of an act, an act of choking which ceases prior to death. And that is, I mean, there's a criminal offence which is still on the statute book, referred to in the citation.
Is the act not the same in both scenarios? The act is the strangulation.
Yes, but it ceases prior to death.
Is that something which invests the phrase with a different meaning, or is it merely an adventitious circumstance?
Well, it doesn't invest it with a different meaning, because the meaning of it is simply that it's an act of strangulation that doesn't lead to death. what we're concerned with in this case is the reasonable understanding of the notional Facebook friend of Miss Bligh coming across these words on Facebook, and whether they would be understood to mean that the claimant was trying to kill the respondent was trying to kill the appellant. That's what we're concerned with here. But it's significant in my submission that when one looks at the criminal statutes, they make precisely the same distinction between the act, which is the try to or attempt to, and the intent that goes with it, as do the CPS in their guidance. What I said at the beginning was one can go into the technicalities and the logical arguments, but at the end of the day, in my submission, this is very simple. This phrase, trying to strangle, is commonly used. It's understood in a particular context, and it doesn't impute an intent to kill. It's as simple as that. And that should be within the knowledge of ordinary people generally.
I mean, your submission is in this context, there's no difference between trying to strangle and strangle.
No. If she had said, he strangled me, it would have been obvious because she was alive, that it wasn't being used in what the judge described as the primary sense. I don't accept there's a primary, secondary sense, but that was where he was looking at it. Yes, it would have, and what he is effectively saying is that she, or any other victim of this rather serious act of domestic violence who wants to avoid being successfully sued for defamation, has to say, he strangled me. Or else risk, by saying he tried to strangle me, conveying something more serious and saying he strangled me, which is, in my respectful submission, an absurd outcome, which the law of defamation, no matter how artificial it is, does not drive this court to reach or uphold. I just wanted to briefly put these words into their context. My submission context is important. As I was saying, they appear in a Facebook exchange between the appellant and Deborah Bligh, who's the respondent's partner. And this exchange involved a status update posted by Miss Bligh and 45 comments on that update by the appellant and Miss Bligh. The respondent only complained of 7 comments containing 138 words, and in order to put the legal submissions into context, it's just worth refreshing the memory on them briefly. They are set out in paragraph 87 of the case, that's on page 67, with some additional words that were in the exchange but weren't complained about, which may be relevant. So the italicized words are those which were complained of, and there are some words which are non-italicized, which were in the exchange at that point, but weren't complained of. I won't read it out loud, but if I can just ask the court to flick through it, because it's pretty brief.
Yes, we have all read
Yes.
this.
And just while you're there, if you can just turn over the page or jump down the screen to page 70, paragraph 102, you can see there the meanings that were complained of by the claimant. Had tried to kill the defendant by strangling her, so that's stated explicitly. Had also threatened her and breached a non-molestation order protecting her, for which he was also arrested. Had been arrested countless times, and accordingly, i.e. because he's been arrested countless times, was to be inferred, was a dangerous and thoroughly disreputable man. As to how the Facebook exchange would have appeared, all we have is screenshots from Deborah Bligh's Facebook wall. In other words, how they would have looked at Deborah Bligh if she had accessed all of them from a computer. And you can see that on page 250 in tab 12. And it goes on to page 253. She actually closed her account before the proceedings were brought, but screenshots before doing so. It's common ground that they would also have been accessible in the newsfeed of Deborah Bly's Facebook friends, newsfeed being a constantly updating list of items. There was uncontested evidence that they were seen by 3 of her Facebook friends, giving rise to a cause of action. Claimant didn't sue on the publication to Miss Bly, just on the publication to Facebook friends. Since the publication took place before the Defamation Act 2013 came into force, there was no requirement on the claimant to prove serious harm to reputation. And if the submissions of the respondent in the show and independent newspapers are correct, the 2013 Act would make no difference in a case such as this, as the meaning conveyed by the statements is sufficiently serious, even in the meaning contended for by my client. So we will have more and more of these types of cases. In any event, what's relevant for the issues raised by this appeal is that Facebook communications such as these are by their nature informal and transient. Or to use the words of Mr. Justice Warby in the Katie Hopkins case, to which I will refer, it is a conversational medium. That case was an exchange on Twitter, but the same point can be made in relation to the Facebook conversation between the appellant and Miss Bly. With that introduction to the factual matrix, just to restate, the points of law of general public importance identified in the grounds of appeal are the admissibility, treatment, and weight to be given to material relating to the usage of words, the words complained of, or equivalent words, and the standard of appellate review on a determination of meaning. The agreed issues on this appeal are set out in paragraph 28 of the Statement of Facts and Issues. That's at page 46, but I can just recite them briefly. Was the meaning determined by the judge correct, and or, as the Court of Appeal considered, one which was properly open to him, particularly given the material put before him by the appellant evidencing usage? 2, what is the correct standard of appellate review in relation to the judicial determination of meaning? 3, assuming the meaning contended for by the appellant or similar is substituted for that found by the judge, should the justification defence succeed? And our answer to those questions can be seen on paragraph 2 of the case on page 48. The judge's finding was wrong for the following reasons. 1, it was not the single most likely way in which the ordinary reasonable reader of the exchange would have understood the appellant's words and was therefore not the single right meaning. Upholding a judge's meaning as to the single right meaning is not a case of merely asking whether the judge has applied the Jaynes principles, I'll be coming on to those, thus arriving at a conclusion that was open to him. The Court of Appeal must form its own view as to the right meaning. The Court of Appeal didn't do that in this case, and we're now before this court having granted permission, and therefore I submit this court has to make its own independent determination of what the right meaning is.
Insofar as it matters, do you go so far as to say it wasn't an available meaning?
I do say that, yes. That's subparagraph 2.3.
Yeah.
Because it involved over-elaborate analysis, contrary to the Jaynes principle, quite wrong to start off with a dictionary definition. And this was not a cross-check, as was suggested by the Court of Appeal. This was a fundamental basis for the judge's reasoning that would apply in any context where the victim was alive and an act of strangulation had taken place. There was no reference to context at all. That was required, well, it was required in any event, but it was stressed by Bukowski, which was decided after the trial in this case. So it wasn't a conclusion that was even open to him, if that's the way we're going about it, which in my submission is a too lower threshold test for an appellate intervention. Linked to that, just jumping back up to 2.2, the judge's reasoning was directly contradicted by material adduced by the appellant evidencing usage of the same or closely related words. I'm not saying that's conclusive, but it's relevant and admissible, particularly where the tribunal bases its reasoning solely on one source. And that source is contradicted. And then in paragraph 3, if the judge's meaning is overturned, it must follow that the defence of justification succeeds on the basis of the proved and admitted facts. Appears the respondent doesn't accept this proposition, but looking at the respondent's case, it seems to be directed to an absence of a finding that the respondent yes, the respondent intended to kill the appellant. Indeed, there was a positive finding by the judge that that was not the respondent's intention. I should reiterate that justification only arises if the meaning is overturned. If the meaning is overturned, and all my client has to show is a violent constriction of the neck, well, that was found by the judge, and that's game, set, and match. So, I'm going to take it in the order of the law governing the determination of meaning, and follow that with the correct standard of appellate review, in the order that it appears in the case. If I overestimate or underestimate the court's familiarity with the technicalities of defamation, no doubt I will be told. We start with the...
I think you and your opponent have done your best to overcome any ignorance on the part of the court.
I'm most grateful for that. Then I will try and go as quickly as I can. We start with the single meaning rule, which I stated really in paragraph 4 of the case, a particular set of words in its context may give rise to a range of possible meanings. It remains a rule of law of defamation, however, the entire claim must proceed upon a single defamatory meaning, the right meaning, chosen from that range. So you have the range, possible meanings, then you have the right meaning, and the court has to decide what the right meaning is. I've set out the classic passage from the judgment of Lord Justice Diplock in Slim, which I don't have to read out. Historically, defamation cases have been tried by juries, and there would be 2 stages to the selection of the right meaning. Judge excludes any incapable meanings. Those are the product of an utterly unreasonable construction of the words. That was a very low threshold for a meaning to surmount. The jury would then select the right meaning from the available capable meanings.
Do you challenge Lord Justice Diplock, as he then was, his observation that in the context of libel, the single meaning is highly artificial?
Yeah, well, I submit it is highly artificial, and this case is a classic illustration of it, because, I mean, the notion that Miss Bly's Facebook friends, insofar as they cared about what they read, would have come away with a broad impression of the respondent, which would be justified by what, in fact, he'd done. But we have to analyse everything extremely closely to come to a meaning, and then the other side of the fence, which is the really important side in terms of free speech, you have to be able to prove, because the burden of proof is on you as a defendant, something that comes sufficiently close to the meaning that's been produced by the first part of the exercise, namely determining what the publication means. So there's always a battle going on between a claimant who may have done something bad to try and push the meaning up to a level where it can't be, whatever it is he's done bad, can't be proved exactly, so he comes away with something, or the defendant gets advised, well, you really ought to be paying something to avoid the cost of litigation, etc., etc. So the claimant's looking for, just to try and get the meaning as high as possible to make it very difficult for the defendant. But I don't know, I mean, I'm not here to argue that the single meaning rule should be overturned. But what I do say is, because of its significance, there has to be proper safeguards to ensure that the court arrives at the correct meaning.
You've referred us to the two stages.
Yes.
In the context of a jury trial.
Yes.
So presumably the first stage drops out of the picture when we just have a judge.
We just have a judge. So we don't even, the baggage of the capability determinations doesn't really help us now in the modern era. And I mean, the Court of Appeal said it was a decision that was open to him. So essentially, it was a capable meaning. And the respondent, in his case, emphasises that he says it was a capable meaning, and therefore you've got to give weight to that, huge amount of weight. We don't have to think about that anymore. We're trying to arrive at the single right meaning, and it's a judge who's going to make that determination.
Is it right that the available meaning concept, when we still had a jury, also indirectly, but in practice, although not necessarily in strictness of law, set the metes and bounds to the scope for intervention by an appellate court? In other words, if the judge correctly directed the jury as to available meaning,
Yes.
and his directions weren't vitiated by any other error of law, then really the jury's choice of the right meaning within that frame, those boundaries, was pretty well unappealable.
Yeah, you can challenge
But
it.
why should the position be different when Parliament has decided that judges can do it even better than juries?
Well, because why should it be? I mean, why should it be the same when we don't even have to worry about a capability test? We're trying to.
No, but what I mean is isn't there a parallel between available meaning in the judge's direction to a jury and the concept when a judge's decision has been looked at by an appellate court? Is it within a range of available conclusions that a reasonable judge could have reached?
Yes, I mean, as we can see from Slim, even when jury trials were the norm, where there was trial by judge alone, it was not enough for the respondent to say this was a capable meaning. Even in 1967, or whenever it was Slim was decided, the Court of Appeal recognised that it had a duty to arrive at the right meaning. And since the whole law proceeds on the basis that there may be a number of, let's keep the phrase, capable meanings, but only one right meaning, then the fact that something is a capable meaning doesn't mean that a Court of Appeal can't decide that it was the wrong meaning, or at least wasn't the right meaning. There's a materially different meaning, which is the right meaning. And that's evident in all the cases in the Court of Appeal concerning appeals from determinations by judges. It's not enough that the meaning is a capable meaning, because just because a meaning is a capable meaning doesn't mean it's the right one. And why, if the question is why should we not just continue with this notion to avoid appeals? The answer to that is, if the law is going to proceed on the basis of a single meaning, which has such significance for the purposes of a defamation claim and impacts on the Article 10 right of the defendant and can result in false vindication for the claimant if the wrong meaning is not selected, it's therefore important that the court arrives at the right meaning. The right meaning being the most likely way in which the defendant's words would have been reasonably understood by her audience. And if the court is of the view that the meaning found by the judge is not the most likely way in which the defendant's words would have been reasonably understood by her audience, the court both has a duty, the appellate court, to overturn that meaning, and it's entirely sensible and right and proportionate that the law should allow the court to do so. The law of defamation itself has not always had the best possible reputation. And false vindications of a claimant, and those arise where the right meaning has not been selected, where the defendant could have justified the right meaning, but the right meaning's at sufficiently high level that she can't justify it. Those sorts of false vindications undermine the public's confidence in the law of defamation and amount to a breach of the defendant's Article 10 rights, which should not be sanctioned. There has to be proper safeguards to ensure that a defendant is not required to prove the truth of a meaning that is not the right meaning.
The law of defamation has to strike an appropriate balance between protecting the Article 10 rights of the person who has made the statement, yes, and the Article 8 rights of the person whose reputation may have been damaged, yes, by it.
Yes. I mean, I suppose I'm jumping now to my section on standard of appellate review. I mean, there's be nothing to stop a claimant from seeking to appeal in an appropriate case. In a way, this is claimant-defendant neutral, or Article 8, Article 10 neutral, but it does tend to be the case in my submission that the process of a defamation case leads to over-elaboration, and over-elaboration leads to a more serious meaning than that intended by the defendant, or that which the defendant can prove. So the dangers are usually the dangers for the defendant, but this point is, in a sense, it's Article 10, Article 8 neutral. But it is a consequence, nevertheless, that if the defendant is required to prove the truth of a meaning which is not the right meaning, and is unable to do so, notwithstanding that she could prove the substantial truth of the right meaning, the award of damages and the substantial costs that would be entailed, plus the injunction against repetition of what would ex post facto be true, a true statement, should be injuncted from making the true statement, all those things would amount to a penalty within the meaning of Article 10 that could not be justified in my submission. It's not necessary or proportionate. I mean, this is also tied in with the with which a court can make a determination of meaning. It's not a complicated exercise. It doesn't involve witnesses. It's not multifactorial. It's just a question of looking at the words, and possibly I would submit in an appropriate case some documentary material evidencing usage.
I mean, you're going to come to Article 10 in due course, but is the Article 10 analysis necessarily constrained, or some might say enslaved, by the right meaning approach which the law of defamation takes, bearing in mind its high level of artificiality?
Is it possible that the artificial nature of the single meaning rule could impact?
Yeah,
could be
that's putting it the other way around.
Yes,
it's the same question.
It is definitely, it is possible to make that case. One would have to look at defamation law in the round. For example, if there was not a meaningful threshold test before a person could bring a defamation claim, which Parliament sought to do with Section 1. So you could bring a claim with there's no reputation just on the basis of a meaning to maybe one or two people. Burden of proof is put on the defendant in relation to truth, large amounts of costs if you lose, complicated, stressful procedure, put all those things together, and you could have a very credible case that English law, defamation law was not consistent with Article 10, and this would be a good case to make that case. I hopefully won't have to, but
it's quite common, isn't it, for there to be meanings hearings before the trial proper?
yes.
There was no such hearing in this case.
No, neither party did so, and there's some attribution of motive in the respondent's case, which is not true. We had a case management conference in front of Mr. Justice Warby, and he accepted that there were possible arguments for having some preliminary determinations, but accepted on balance that he could see why the parties weren't inviting either. So neither the claimant nor the defendant did so. Perfectly frank, as far as my understanding was that the minute there was a finding that the claimant had, in anger, put his hand around the defendant's neck with such force that 2 hours later the police saw red marks. As far as I was concerned, I thought that would be the end of the case. It didn't go that way at trial, and whatever the meaning was, but what happened before trial was that Mr. Barker suggested a preliminary determination of meaning at the beginning of the trial, so not the ones that we're having now, which are right at the beginning of the case. And I said that it would be better to make findings of fact on the evidence and have it all done in one go, because the way in which the evidence panned out could make a finding on meaning redundant. And the judge decided to approach it in that way. I mean,
So in the end, it wasn't contested before Mr. Justice Warby?
No.
So his view about the answer to the Section 1 Lasho question didn't have any bearing on it?
Yes, because Section 1 wasn't engaged.
Yeah.
I mean, I was just looking back over the transcript of the trial. I had quite an interesting discussion with a judge about Section 1, because the trial took place in 2016, and I had a sort of job lot of these types of cases of individual defendants getting sued for website or transient publications, which has ceased after Section 1 came into force, and particularly after the Cook case. And now we see them coming back following the Court of Appeal's decision in the show, where all you have to do is get to a meaning and you're in. Nothing else. And then all the work's for the defendant. And lots of defendants obviously don't want to put in the work. This was a case where we did have a police statement which referred to red marks around her neck that the police officer had seen 2 hours afterwards. So fortuitously, my client was in a better position. There are many things that I could say about the current law of defamation. I made a number of submissions in the context of the showcase, but I'm here as an advocate for Mrs. Stocker, who is an individual who has no brief to try and change the defamation laws. Obviously, she would rather something like this didn't happen to somebody else, but I'm not challenging the single meaning rule. I say it can work unfairness to a defendant, and that's why it's particularly important there are proper safeguards to ensure that the court arrives at the correct meaning. I don't think I can go much further. I mean, I do submit, though, that this finding in this case is a breach of my client's Article 10 right, given what she was able to prove and given the words she used. I respectfully submit that it is important, perhaps, for this court to actually define what is meant by the right meaning, because it hasn't been articulated in any previous case. My learned friend...
Well, I mean, are we really in a position to deal with an allegation of a breach of Article 10? I mean, for example, I'd thought what would strike the Strasbourg court is the costs of the case.
Yes.
And they might expect, if they thought that it was out of order, they might expect the UK to put some sort of cap on counsel's fees in these cases. Yeah. I don't know. But it's not an issue in this appeal.
No, I mean, there's also the dangerous imputation, allowing that in as a freestanding imputation. But no, I mean, I was asked by my Lord Briggs about whether the single meaning rule was a breach of Article 10, and I gave the answer I didn't. I also dealt with it in the specific rather than the general. I'm basing my submissions on what I submit are conventional principles of defamation law. And in terms of the standard of appellate review, whether the court accepts the submissions that I'm making, which is a sort of Bukowski just taken a little bit further, even on the proposition A in Bukowski, which was the higher test for an appellant who's seeking permission to appeal, the Court of Appeal didn't approach it even on that basis. They approached it on the basis of capability, and they said it wasn't a rehearing. So I want to stress that fortuitously, I do not have to ask this court to do anything that is too radical. I'm asking this court to formulate principles consistent with previous decisions in an era of judicial determinations of meaning.
I think your argument is it not, that the application of the single meaning rule in this instance constitutes a breach of the appellant's Article 10 rights, because a single meaning which has been chosen by the judge unwarrantably restricts her freedom of expression under Article 10.
Well, no, I'm saying that if there's a failure to provide a meaningful appellate review, then there is. I can't, you know, the court will only look at it after you've gone through your remedies. I accept, I am not, let's put it another way, I'm not submitting the single meaning rule is contrary to Article 10.
No, I was careful to say the application of the single meaning rule in this instance. If I've understood, I may have misunderstood your argument.
We're not at the end of the road yet. I'm still hoping that the application of the single meaning rule, that the English court will deliver a finding.
The application of the single meaning rule by the judge in this instance, I would have thought you would want to argue, constitutes an interference with the appellant's Article 10 rights.
I do. And
because the consequence of that argument, if it is correct, and I have no view at present as to whether it is correct, the consequence of that argument may be that when the judge approaches the question of the single meaning, he should have, or she should have in mind the Article 10 rights of the defendant.
yes.
And that the selection of the single meaning in a particular instance should be, where appropriate, influenced by Article 10 considerations.
Yes.
Article 10 isn't mentioned in the issues in the SFI.
I'm not always frequently before this court. I mean, is it a requirement?
Well, I don't know if it's in your grounds of appeal either. I mean, what's striking me is that if you had a complaint of a breach of Article 10 in this case, if that were what this hearing was about, we would be asking ourselves, why did this case take 4 days to argue about the meaning of 4 words? Your client hasn't had to pay any damages. She has been found liable, I understand, for an enormous amount of legal costs, which are charged by the lawyers in the case.
Yes.
And the focus would really be on why is it so expensive to litigate defamation cases in this jurisdiction? Why did this case take 4 days, which is why the costs are so high? And is that potential liability a disproportionate interference with the right to freedom of expression? These aren't, as I understand it, issues that you've come here to argue at all.
What I'm arguing, I can take the court to the references to Article 10 in the case, and there's also references to Article 10 in the grounds of appeal, but I don't want to get too distracted by them because it's not a necessary part of my appeal. What I submit is that if a defendant is required to prove the truth of a meaning which is not the right meaning, when she can prove the truth of the right meaning and she ends up having to pay damages, legal costs, and also the most serious and restrictive of all forms of restraint on free speech, an injunction against repetition, which is a consequence of this decision, then in those circumstances, a breach of Article 10 has happened. And it's for those
I'm sure that's uncontentious.
and that's why it's important that there's a proper opportunity, that the court should strive to arrive at the right meaning, and that keys into the 2 points of law of general public importance on which I rely, which is the proper standard of appellate review and the availability of evidence of usage, where relevant, to stop the judge, the usage to stop the judge going down a wrong path, and the right of appeal to ensure that it is a proper opportunity to review. And yes.
Not being satisfied in any technical sense, then that part of your problem with this would go.
Yes.
And we'd be left just with the evidence.
Yes. 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 I'm submitting that the submissions that I'm making are consistent with established legal principle. I can just come back to the meaning of the right meaning, because I do submit it hasn't been articulated. I'm on paragraph 6 of the case. Fortunately, I've dealt with a lot of things further on in the case now that I won't have to go to. I'm just still on this point, if I may, because I do say it hasn't been articulated, and I come back to this. The right meaning is the most likely way in which the defendant's words would have been reasonably understood by her audience. My learned friend said, well, there's plenty of definitions of the natural and ordinary meaning, and that's true, and he points to one in Charleston, which is the meaning that the words would convey to the mind of the ordinary, reasonable, fair-minded reader. Well, that's very well as perhaps a way of arriving at capable meanings, but it doesn't help to determine, when you have a number of meanings that could be described as reasonable, which one is the right one. So I submit that, again, the focus has to be on the most likely way in which the defendant's words would have been reasonably understood. That must be the consequence of having a single meaning rule. At least you're trying to go for the most likely option, which would then, in theory, reflect the reputational harm that has been caused.
You're not intending that formulation to be statutory, I'm sure, but on one view, it's slightly too subjective, isn't it? You ask what the audience actually thought and then ask whether it's reasonable, where in fact we're doing the exact opposite, aren't we? We're just looking at a class of people
Yes.
of the same type as the audience,
Yes.
and then conducting a purely objective test by reference to the approach to language of that class.
Yes.
In context.
Yes.
So you can distinguish between rocket scientists and readers of the Daily Mail, depending on who it was,
Yeah.
who read the publication was to. But you don't ask about the particular rocket scientists who read it.
No. Of course, the test is objective. It's not about, the defendant can't give evidence of what her intention was in relation to the words that she used, can't call witnesses to give evidence as to how they understood the words, not challenging any of those long-established principles. I do submit, insofar as it matters in this case, and primary submission, it doesn't matter if you take into context, but insofar as it matters, there does remain an element of subjectivity. It's accepted, there's Court of Appeal authority, that the perceived intention of the publisher may well colour the meaning of the words. And if you think about it, a reader ordinarily determines meaning on the basis of perceived intention. And if you were to base a system of construing words for the purposes of defamation, of a defamation claim that was supposed to replicate the reality of reputational harm as closely as possible, you would want a meaning that reflected perceived intention by the audience, because that's the sort of sting of it. It's what the recipient of the publication thinks the defendant is intending to communicate. So in paragraph 8 I say the question is not what does this statement mean, because that leads to abstraction. It should be what does the ordinary reasonable reader understand this defendant is intending to communicate through these words. I stress, through these words, not anything else. And if you put it this way, it's rooted in the particular circumstances and context of publication. Gatlin wasn't keen on going too far down the road of perceived intention. Just actually, the footnote reference is Lord Justice Neal in Burkoff and Butchill, where he says the perceived intention of the publisher may well colour the meaning of the words. I don't want to spend too much time on this issue, so long as we bear in mind that the primary issue is to ensure that context is taken into account. Whatever the correct question is, there's no...
Well, I see the judge did direct himself that the hypothetical reader is taken to be representative of those who will read the publication in question, quoting from James.
Yes.
Yeah. So he will have had in mind what the ordinary person with access to that Facebook page would have made of it.
Well, but if you actually look at his reasoning, it's context. It doesn't take into context at all. It's universally applicable. If we just jump to his reasoning, which is paragraph 59 of the case, page 61. It's just one paragraph. Paragraph 36 of his judgment. So what's evident from that paragraph is, first of all, he hasn't used the Oxford English Dictionary as a cross-check. He's used it as the foundation of his reasoning. Next, his reasoning is unequivocal. If you go down two-thirds of the way down, but the two Facebook comments cannot have been understood to refer to trying to strangle her in that sense, because, as she said, the police had found handprints on her neck. These could only have been caused by the painful constriction of her neck or throat. If understood in that sense, she could not have been taken to have said the defendant had tried to strangle her because he had succeeded. So the entire reasoning is based on the Oxford English Dictionary definitions and the first and the second. This is an analysis which would apply in all contexts.
Well, they're not in dispute, are they? I mean, is it not clear that those are, in principle, two alternative meanings of the words?
Well, I don't admit they're alternatives, but the point that I was trying to make was about the judge taking into account the class of readers. Mm-hmm. And so in answer to that point, what I was saying is that this analysis doesn't take into class of readers. This could be any reader.
I mean, his analysis is really based on logic. I mean, he's saying that as a matter of reason,
yes,
she can't have meant tried to squeeze my throat, because clearly he hadn't simply tried to do that, he'd succeeded in doing it.
Yes.
And so that's why he says the ordinary reader would have read the words differently, as meaning tried to choke me to death.
Yes.
So, I mean, you're having really to tell us that the ordinary reader of a Facebook page doesn't read things in that logical kind of way.
Well, I hope I've dealt with the logical point when raised by my Lord, Lord Kerr. I don't say that. I try to submit that it's not logical to regard try to as imputing a mental state, and I don't accept that these two definitions of strangle are different. I mean, or that you need a dictionary to know what strangle means. It's a constriction of the neck. Sometimes it leads to death. Sometimes it doesn't. But the reason I came to this passage was to address the point that my Lord made about taking into account the class of readers. I mean, He's not doing that. He's not basing it on context. It's a once and for all approach, simply based on what the judge regarded as the logical consequences of the word she'd used in the light of the dictionary definition.
Talking about context, nobody's made anything of the concession that she might not be the most unbiased observer with regard to this. Was anything made about that at any stage? Is it part of your case, that it's part of the context?
Yes, I mean, the stronger point was he spent a night in the cells. I mean, it's just sort of conversational discussion. It's not being pitched at a level of an indictment.
I don't see why the stronger point is he spent the night in the cells. It seems, anyway.
But no, but my lady, the nature of this process is that points that seem of significance to some may not have been picked by others, and it's an impressionistic basis. I mean, I put those words in. I may be biased, mainly because it was clear that she was expressing an opinion, anything that was following, in a sense, although they were statement of facts, as far as it conveyed any further impression, was one of opinion, her particular take on things, and that's why I put those words in. But yes, they are. I mean, the reality of this is that it didn't cause any harm to the claimant. I mean, this was something that just came and went on Facebook. He dismissed as the rantings of his ex-wife. The extent to which I can bring all this into this appeal, I don't know. But if it strikes your ladyship that those words are significant, then that's entirely valid. But I have to
Asking you not to.
Well, all I can say is that I have not made reference to those words or relied on them in context. I've just put forward the very simple point that this was a way of her trying to describe an act that was caused to her. All that matters in this exchange between the two of them in this conversation is what has Terry done to get himself arrested. And one of the things he'd done was he strangled me, to put it in the way the judge would have. She should have said, he strangled me. But people don't say that when they're alive. He tried to strangle me. He choked me, didn't kill me. Obviously, I'm here. That's one of the things he did which led to him being arrested. That's it. Coming to the process of interpretation, the reasonable reader, the court will be aware of the Jane's principles. They're highly generalised, and they're actually directed to, in my submission, a different task to the task that the judge must undertake when determining the single right meaning. They have some bearing on that, because obviously the governing principle is reasonableness. But all these principles are directed to excluding incapable meanings. Question how helpful they are now. And I should just stress, there's nothing in Jane's which is in any way harmful to my client's case. Clearly my client relies on Jane's Principle 3, over elaborate analysis is best avoided. I'm going to move on to implied or inferential meanings, which is paragraph 14 of my case on page 51, but I've already dealt with a number of these points in the course of dealing with other matters. So I think I said to my Lord Briggs, most of these disputes involve an implied meaning contended for by the claimant as the meaning which is denied by the defendant. Classic example, a defendant describes accurately in good faith an act carried out by the claimant, but the claimant alleges that the words used impute to him a particular mental state, and hence a criminal offence more serious than the act sought to be described by the defendant. Allegations involving domestic violence and sexual harassment are prone to give rise to such a dispute. It would appear that the law of defamation may have reached such a level of artificiality that the victim of such an act can be liable in damages to her aggressor if she frames her truthful description of what happened in words that inadvertently give rise to an imputation as to his state of mind that she's unable to prove. If that is where the law of defamation takes us, it's all the more important to ensure that her words do in fact bear that meaning. As I've said, I'm not trying to change the single meaning rule. That appeared to be what Liberty was trying to do. And its attempt to intervene was rejected by this court on the basis that this appeal involves the technical principles of defamation law. As I said, my client is an individual with no interest in the law of defamation other than the outcome of this claim. I've made the points about the disadvantage of the single meaning rule and the context in which it appears within the law of defamation. I think I've also made the points in paragraph 18 about the public policy considerations in play, the consequences of a meaning determination. I emphasise what Lord Devlin said in the Lewis case in 1952. That was the context of a report of a police inquiry, and the issue was whether one could infer guilt from the fact that the police were investigating the affairs of the claimant. And in that context, Lord Devlin said that if inferences are too readily drawn, it would be impossible to give accurate information about anything. So put all that together. I'm now in paragraph 19 on page 53. Put all that together, and it's important that where the claimant advances an implied meaning that's materially more serious than defendant's contended meaning, proper safeguards are in place to ensure that it's the correct meaning. And these concerns are more acute where we don't have a jury any longer, we don't have 12 ordinary members of the public, but we have one lawyer from a relatively narrow pool of other lawyers with similar life experiences and with respect to tendency to analysis and to looking at things in the most logical way possible. There have been some developments subsequent to Jane's. The first, we've mentioned the abolition of trial by jury. Second, there's a refinement on Principle 2 from the Lord McAlpine-Burko case, which I don't think is relevant to the present case, but if it is, my learned friend can refer to it, but I put it in there because it is a development. And the third one, which is the important one, which I touched upon, is Bukowski, where the Court of Appeal held that these Jane's principles that have been cited time and time again omit an important principle, which is the context and circumstances of the publication. We'll come to Bukowski when we look at the standard of appellate review. Now, the context and circumstances were held to be a relevant factor in Bukowski, and it's clearly a relevant factor in the present case. And the court in Bukowski relied on Gatley, paragraph 330, head of the context and circumstances of publication. The supplement, unfortunately, is not in the bundle, but the relevant passage is cited below from the Katie Hopkins case that I mentioned in my opening, where you're dealing with a conversational medium. The warning against over-elaborate analysis, that's Jane's paragraph 3, is particularly fitting. Don't think that's controversial.
I beg your pardon, where are you reading?
I'm sorry, it's paragraph 24 on page 54 of the case.
Right, thank you.
So this is a development that has happened after the Jane's case, where those principles were set out. In Bukowski, it was noted that Jane's didn't refer to the context and circumstance of publication, and the learned editors of Gatley have picked up that in the supplement following the Katie Hopkins case. That was the one on Twitter, because of course we're getting more of these types of cases now. inevitably. And it says that one has to take into account the nature of the communications, the more modern forms of communication, particularly where they're conversational mediums. And that's where the warning against over-elaborate analysis is particularly fitting. And just for the avoidance of doubt, when I say that submit that the judge's finding was not a finding that was open to him, one of the reasons for that is that it involved over-elaborate analysis, contrary to James 3, particularly taking into account the context of the publication. And just to be absolutely clear, I'm now on paragraph 25, the contents and circumstance of publication include the mode of publication and the context in which the relevant allegation took place. So in this case, that means a Facebook exchange between two women who aren't lawyers, and Facebook friends of one of those women who would not be treated as lawyers, and the subject matter is an act of domestic violence.
Can I just mention, in a spirit of being helpful,
Yes.
that so far you're simply taking us through your written case.
Yes.
We have all read it already.
Yes.
You've got about an hour and a quarter left. If you're wanting to develop your argument beyond the case, then and put something new in front of us, then that's the time you've got left to do that.
Yes. Well, I mean, I think I've covered quite a bit from beyond, as it were, in terms of the application of the law, the legal principles which I contend to the facts of the case. I finished now my legal submissions on the determination of meaning. I was going to move on to the standard of appellate review, and I was intending to go through the case law, which I think I do have to go through, even though I've mentioned it briefly in the case. That's my intention. I think I'm within time at the moment. I know I've got a cut-off at 12:45, but I'm most grateful for that. These are my legal submissions on the correct standard of appellate review, which I will go through as quickly as possible, bearing in mind the court has obviously read the case. I stress 2 points: the importance of the determination, the nature of the exercise. I've been through the importance of the determination, already made my submissions in relation to paragraphs 27, 28 and 29. 29 deals with the European Court of Human Rights jurisprudence. And there's a difference in my respectful submission as to whether the outcome, the final outcome of a case in these courts involves a breach of Article 10 on its facts, and whether the legal principles that led to that are inconsistent with Article 10. My point is that one needs to make sure that the legal principles are consistent with Article 10, and if those legal principles are applied in a way which is consistent with Article 10, in my submission, one gets to the right result in this case. These principles for determining meaning don't only arise in defamation claims now. We've got data protection claims which are coming increasingly before the court, and issues arise as to whether data is inaccurate. In order to determine whether data is inaccurate, you have to determine what that data means. Mr. Justice Warby, in the leading case of NT1 and Google, held that these principles, the Janes principles, apply to data protection claims. We've had them applied to a judicial review claim relating to the publication of the outcome of an investigation by the Financial Reporting Council. Did that investigation impute misconduct to a particular person? That had to be determined by Janes. Similarly, in a harassment claim, we're in the same position. So it's a very important determination, and it's really straightforward. In this case, the court simply has to look at those 7 comments that we saw at the beginning and arrive at their meaning. And in fact, the meaning of the words "try to strangle" in that context doesn't mean intent to kill, or doesn't mean an act of strangulation. As to the case law, I've already dealt with, in answer to a question, the difficulties of appealing a determination of capability, and certainly a finding by the jury that, as to what was the correct meaning, following a judge's determination that it was a capable meaning. There's no reason for that to percolate into a judicial determination of meaning, and indeed the law does not and has never required it to do so. With that in mind, can I turn to the Slim case, which is Authorities Bundle 2, tab 25, and it's page 617 of the electronic bundle. I'm not sure if that's the start of the case.
Did you say 617?
Yes,
Yes,
617,
yes.
yes.
Thank you.
Yes. This is in the Court of Appeal.
Yes. I rely on this case for the proposition that it's not good enough if the respondent wants to prevent the Court of Appeal from exercising its own judgment as to meaning, for the respondent to say, hang on, these meanings are capable meanings, that is the end of the inquiry in a judge determination. That was the argument that was put, and it's dealt with most clearly in the judgment of Lord Justice Salmon on page 186F onwards. I've cited part of this paragraph in paragraph 35 of my case, but I apologise, there is a wrong reference in paragraph 35 of the case. It says 181E, and it should be 187A. If one goes through that long paragraph starting at 186F, one can see that the Court of Appeal rejects the submission that if the words are capable of bearing the meaning found by the judge, because that a jury, you wouldn't be able to interfere with a jury finding in that circumstance. It means you can't interfere with the judge's finding. I've extracted in the case.
It's implicit, isn't it, that Lord Justice Salmon thought it was still a finding of fact, however closely it may approximate to what a judge is doing when construing a contract and applying the same single meaning test, albeit it's a slight variation of the single meaning test, but it's the same objective approach based on context.
Yes, one correct meaning.
That's generally regarded as a question of law, once
Yes.
you've found the facts and the context.
Yes.
But it's quite clear here, at any rate, that it's a fact question.
Yes, I mean, one asks, does it really matter whether it's a question of fact or a question of law?
Well, it might on the question of the standard of appellate review, mightn't it? Because on the whole, an appellate court is always more inclined to interfere on questions of law than questions of fact.
One of the reasons for that is that questions of fact often involve
I appreciate
witnesses
that.
and multifactorial
Yeah.
issues. Even if they're paper-based, there's a whole series of factors that could come into it. Whereas you couldn't have it'd be impossible to think of a situation where the appeal court was at least equally in a good position as the trial judge, and it could be done really quickly. So this is quintessentially the right sort of thing that one should be considering again, particularly bearing in mind the seriousness of the consequences. But in any event, I rely on this case for the authority.
You may or may not know this court has decided quite a number of cases over the last few years about review on questions of
Yes.
fact, and a point that's been made is that the reasons for restraint by appellate courts aren't simply to do with whether they may be in a less good position to reach a decision. They're also to do with what the proper role is of appellate courts as compared with first instance courts and a proper use of judicial resources.
Yes, I readily accept that. I mean, even when if one takes it in stages, one could have a case which turns on the credibility of witnesses. Very, very hard to overturn that. One could have a case that doesn't involve any credibility issues, but which is multifactorial. And again, while it could be said the Court of Appeal is in as good position as a trial judge, as a reluctance to interfere, partly because I think there's some statement from Lord Hoffman, I can't remember off the top of my head, which talks about the various influences that will come to that the judge relies on.
Biogen,
Yes.
I think it's the case you have in mind.
That's the multifactorial case where there's no credibility issues, where it's at first blush, you might think the Court of Appeal is in a better position, is in as good a position as a trial judge, but in reality it may not be, even if no credibility issues. And also it's quite a difficult exercise, so one is thinking of case management issues. And then you've got this, which is purely paper-based, straightforward. So in terms of case management terms, you've got something which is easy to deal with and could be dealt with really quickly, especially if procedures are in place for that to happen, and a very important outcome which impacts on the Article 10 and possibly Article 8 rights. So this is not a situation where, well, there's always a concern about ensuring that appeals don't take place unnecessarily. Of course, that's right and proper. The approach of the Court of Appeal in Bukowski at the lowest is the correct approach. I'm pushing it slightly further than that, but even if one takes the approach of Bukowski and applies it to the facts of this case, the Court of Appeal didn't do what they should have done. So it's obviously, I totally understand the policy considerations at play and the reasons why this court may be reluctant to encourage appeals as a matter of policy. But one can see in the judgment of Lord Justice Salmon some key points here. It's not a sacrosanct finding. And there's no sensible reason why in a libel action it should be more sacrosanct. There's no sensible reason for making it harder in a libel action than, say, a contract action, where it's just a pure question of meaning. And in fact, there are good reasons why it should be less sacrosanct, because a contract case is not ordinarily going to engage human rights considerations, free speech considerations, which is a free speech benefit, not only for the person making the speech, but the person receiving it. And of course, this case involves a specific form of publication, but we're talking about legal principles that have got to apply across the board in defamation claims. So Lord Justice Salmon refers to not lightly interfere and being satisfied. The next relevant case is Skews. Oh, I should just add, sorry, that he also said, I'm as satisfied as I can be. The judge's decision was wrong. That's at B. So we start getting this sort of hybrid situation where there's no jury, so we can, just the fact it's capable doesn't mean that we can't interfere, but then we need to show a little bit of deference. The next case is Skews, decision of the Court of Appeal, Sir Thomas Bingham. That case can be found on page 604 of the electronic bundle. It's volume 2 of the Bundle of Authorities on tab 24, hard copy. In this case, which involved a Home Office forensic scientist who gave evidence at the trial of the Birmingham 6, the trial judge found the following meaning of a television programme. One can see at the bottom of page 604, last sentence, Mr. Justice Brooke ruled that the words complained of were defamatory of the claimant and bore the meaning that there were reasonable grounds to suspect that the plaintiff had been negligent and this had caused or contributed to the wrongful imprisonment of the Birmingham 6. And the Court of Appeal actually upped the meaning. And one can see that at paragraph 11, from a reasonable grounds to suspect negligence to an allegation of negligence. The programme suggested that he had in fact failed to show the skill, knowledge, care and thoroughness to be expected of him in that role. Sir Thomas Bingham cited Slim and then added, I'm afraid this judgment doesn't have the same paragraphs numbers in them as I have cited from in the case, but if one can go to page 613, page 287 of the case, with the subparagraph 8, cited this subparagraph in the case, and there we have the test of quite satisfied he was wrong. But what one can see from this case is it's not about Mr. Justice Brooke arriving at an incapable meaning or not applying the relevant legal principles. It's simply a case that matters that were regarded as significant to the Court of Appeal were not to the judge, and vice versa. There's references to the judge not giving sufficient weight to various factors. What the Court of Appeal is saying is we don't think this is the right meaning, and therefore we're substituting our meaning. The next relevant case is Waterstone and Lloyd. That's at tab 27 of volume 2, page 687 of the electronic bundle. Here's a case where the Court of Appeal was split. One of the judges was willing to uphold Mr. Justice Tugendhat's determination. Two of them weren't. So the two that weren't, by definition, had arrived at the right single meaning. In that case, the issue is whether an MP's expenses claim was alleged to be a scandal. Did this suggest that it was unlawful or contrary to the rules? Mr. Justice Tugendhat held that it didn't. Lord Justice McComb gave the leading judgment on the majority, and that can be found at paragraphs 50 to 62, page 700.
Thank you.
You can see the references to Skews, to Janes, to Slim, paragraph 51, Lord Justice McComb observes, in his opinion, that insufficient regard was given to the second and third principles in Janes. Insufficient regard by the judge, the third principle being that of over-elaborate analysis. Lord Justice McComb was of the view it simply meant it was a scandal, his expenses claim. It didn't mean that it was an unlawful claim, it meant nothing more than that. When one goes through the judgment, one can see again it's a matter of impression. It's not, no one's saying that Mr. Justice Tugendhat, who has vast experience of defamation claims, arrived at an incapable meaning, or...
Lord Justice McComb appears to be applying the I'm as satisfied as I can be test, doesn't he, in paragraph 52? Yes,
satisfied as I can be. These different formulations are all addressed in Bukowski. The riders on what you do as the Court of Appeal when you've reached a different impression to the judge as the natural order. Do you hold back? So do you countenance a situation where if you were the trial judge, you would have reached a different meaning to that which the trial judge did arrive at, but nevertheless, notwithstanding that, you're still going to allow the trial judge's meaning to stand? Another example, as I say, of this not being an issue of capability, it's just a question of getting to the right meaning. The next one, which is an important one...
I suppose you could categorise paragraph 53 as Lord Justice McComb saying really he's acting too much like a judge and not enough like a jury.
Yes. Yeah. So this is the point about over-elaborate analysis, that's a scourge of defamation claims generally, and a particular problem when you've got a judicial determination because you've just...
It's not just elaboration, is it?
No, it's going down a logical route, perhaps, that because you actually have to spend, you have to get to some of these meanings, you've got to put in the thinking time necessary to do so, which an ordinary reader isn't going to do. But a judge, because he's confronted with this and faces arguments and is being given a logical route to go down by the claimant, has to address all these things. That's the artificiality of the legal process that I've referred to previously. And what Lord Justice McComb is saying, well, I read this for the first time and I didn't get there. And what's happened here is that a legal approach has been taken that doesn't replicate how the words would have been understood in the real world.
Lord Justice McComb is saying that the trial judge took the wrong route to
Yes.
getting to the answer,
Yes.
and that's a legal error.
Well, I mean, the Jane's principles are quite flexible. And so there's no bright line where reading between the lines becomes over-elaborate analysis.
But it could be said that what was going on was that the judge was getting to the lawyer's meaning, and that's not right. That's not the meaning that's the meaning looked for.
Yes.
So I'm just trying to think about what impact this has in relation to the appeal standard.
Yes. Well, if one has to establish the decision wasn't open to the judge, in other words, he's made an error of law, then it can become more difficult. But in many cases, you could say the judge has made an error of law because he has looked at it like a lawyer and not as a layperson.
And ignoring context.
Yes.
Second submission.
Yes, and ignoring context. So you could hang these things on Jane's principles, but what I submit is more realistic in the modern era is just to go for the right meaning. The court needs to get to the right meaning, which is the most likely way in which the words have been understood. That must involve the Court of Appeal arriving at its own view of what it would have done if it was the trial judge. And then the next issue is the pause.
Is there a distinction between the Court of Appeal saying, I think this meaning, which is different from that chosen by the judge, is right, and the Court of Appeal saying, I am as satisfied as I can be that the judge was wrong?
No, I don't. Oh, sorry. The question was, is there a difference between me saying I don't think this is the right meaning and I'm satisfied as I can be that the judge is wrong? I submit not in reality, because in practical terms, and I've never been a judge, and having sat as a trial judges and as appeal judges, this is an exercise, no doubt, which is familiar to you all. But I think what's sort of being said is that you would have decided it differently, but how confident do you have to be that you're right and the judge is wrong? I suppose, is what's sort of being said. In my submission, all that matters is that you would have decided it differently. Because
if you look at both the majority judgments, and for all I know, you'd get the same reading Lord Justice Richards's, they don't just stop at saying, well, I've applied the same principles as the judge applied. I'm sorry, but I just come to a different view. They do condescend to explaining why they thought the judge went wrong in principle. Slightly different principle. I mean, if you look at, I'm just looking at Lord Justice's laws.
Yes.
I mean, they don't
Yes.
have an exact concurrence of view about where the judge went wrong in principle, but they both base their findings
Yes.
on the fact that the judge did go wrong in principle.
I readily accept that Waterstone is one case where you could also say that the judge went wrong in principle. Question exactly what you mean by went wrong in principle, because no doubt Mr. Justice Tugendhat would have cited the relevant principles. It can't be just that you don't cite the relevant principles. But the other cases, there's no suggestion that the judge was wrong in principle. It's just a different impression that the court has taken of the matter, which in my submission is sufficient. On the facts of this case, I do submit that there was an error or errors of principle. But I'm contending for a standard of appellate review that doesn't require an appellate to show that. And in my submission, that's a logical consequence of the law applying a single meaning and the important consequences that flow from that.
Depends how you read paragraph 53. On the one hand, he does say, as my lady has pointed out, that the technique of the lawyer was inappropriate. But on the other hand, he also says that the meaning is simple, and it's that stated by Mr. Rampton.
Yeah.
It seems to me that that partakes of at least potentially a dual exercise. On the one hand, saying, well, the technique deployed here was wrong, but also, just looking at the statement, I consider that the judge was wrong to reach that conclusion.
Yeah. But I think those two approaches that have the similarity of this was a small number of words that meant what they said and didn't go really beyond it. And whether you reach that view just because that's the way you read it, or whether you try and tie it to one of the Jane principles, what matters is the end result, that this is a better meaning, and one, as it happens, protects the defendant's free speech rights in the context of this particular speech. But I don't submit that the fact that it's political speech in any way alters the determination of meaning. These principles have to apply across the board. This is a case, certainly, where it's possible to read the judgment as suggesting that the judge erred in principle. If one moves to the next one, which is Cruddis and Calvert, which is a newspaper expose of offers of donations for access to ministers, one doesn't see, in my submission, any suggestion of an error of principle by Mr. Justice Tugendhat. That case can be found on, well, certainly the citation on which I rely can be found on page 396 of the electronic bundle. It's volume 1, tab 14 of the authorities bundle. Perhaps if we can start on page 395, paragraph 16. So the battleground there was the claimant was contending for a meaning that he was criminally corrupt in offering access to ministers for cash. In other words, he committed a criminal offence. And the defendants, publishers and journalists in the Sunday Times are saying his conduct was inappropriate, unacceptable and wrong. And as I say, Mr. Justice Tugendhat found that the articles did impute a criminal offence of corruption to the claimant. Court of Appeal disagreed. Lord Justice Longmore, having cited the relevant principles, simply said, I would conclude that the defendants are not asserting that Mr. Cruddis was criminally corrupt in offering access to ministers for cash. And he says it's an over-egging of the pudding. And then he approaches the question of the proper standard of appellate review. Before I go to that, just pausing here, why this case is significant is because it's a justification case. It's a case where the defendants want to justify the less serious meaning, and the claimant is contending for the more serious meaning that the defendants can't or aren't seeking to prove. And the judge has made the finding in the more serious meaning. And at paragraph 18 on page 396, Mr. Brown repeats the submission made by the respondent in the Slim case and which is made again by the respondent in this case. Judge is the best person to make the right decision, shouldn't be second-guessed. And the relevant paragraph on which I rely is 19. Lord Justice Longmore said, there is, of course, considerable force in this argument. On the other hand, imputations of criminal conduct are extremely serious. And if an appellate court thinks that an article just does not bear that imputation, it should say so. It is an important aspect of the law of libel that it should be open to a defendant to justify a lesser defamatory meaning than that alleged by the claimant, if that is the right meaning to be given to the article. Particularly rely on that sentence, consistent with all the other points that I've made about the importance of the determination and the ease with which the Court of Appeal can have another look.
The Lord Justice Longmore there appears to be bringing into the consideration the nature of the imputation. Is that a material matter for us to take into account in your submission?
Yes, I mean, if the defendant can prove the truth of a serious imputation, or be one not as serious as the one that the claimant's contending for, he should be allowed to do that, because he can't do that. In fact, there's a risk that his claim would be struck out if there was an early determination of meaning, and the meaning that was found by the court was more serious than that which he could prove, and may not even have a justification or truth defence being allowed to be run. In my respectful submission, it is a particularly offensive. It should be particularly offensive for a defendant who can prove the truth of an imputation to lose a defamation claim, because the court has said that the article bears a meaning that's more serious than that which he can prove, when in fact it's not the right single meaning of the article. False vindication.
Yes, but I don't think you can reason backwards by saying because the less serious imputation can be justified, that is the one to be chosen. I mean, if the right meaning is the more serious imputation, well, that's that.
Oh yeah, absolutely, of course, yes. I'm not trying to argue against a single meaning rule, but we're making these submissions. I'm making these submissions in the context of the correct standard of appellate review, and in that context, I rely on what Lord Justice Longmore has said there. He then cites Slim, and then at 21. One treats any decision of Mr. Justice Tugendhat in this area of the law with enormous respect, but as Lord Justice Salmon says, if one is satisfied the judge's finding is wrong, it's one's duty to reverse him. And then he goes on to say that he's satisfied the words don't carry the imputation that he was criminally corrupt. I'm now looking at paragraph 22 after he cites from the Merchant of Venice. And then he says, if, in order to come within Sir Thomas Bingham's eighth principle in skews, I have to go this far, I will say that I'm not merely satisfied, but quite satisfied, if I have to do that. And then finally, we come to Bukowski, where these various formulations are considered. That's tab 10 of bundle 2, or page 356 of the electronic bundle.
I'm sorry, I'm catching up here, reading my way through this. I see, rightly or wrongly, Lord Justice Longmore does identify a legal mistake by the judge in paragraph 17 towards the end. It seems that the judge inferred, found that there was an imputation of criminal corruption, and in part he justified that on the basis that the defamatory statements involved an allegation of a breach of Section 61 of the Political Parties, Elections and Referendums Act 2000, and Lord Justice Longmore points out that's a substantively different offence from criminal corruption. And in the sentence that bridges that page and the next, says he doesn't think it was right for the judge to infer from a willingness to breach that provision that the claimant was being alleged to be personally criminally corrupt. So he has actually identified a specific mistake.
Yes, I mean, when does a mistake become an error of principle? I mean, if one is reaching a different view to the judge as to the most likely way in which words can be understood, then there's going to be certain things which weigh more heavily in the appeal court's mind than it...
No, I think my Lord's point is that this is a legal error. He misconstrued the legal provision, and that opens the gateway to a more ready reversal by an appeal court.
Well, he's not tied it to it being a legal error or tied it to any area of principle.
No, that's a fair point.
And certainly in Slim, the approach wasn't that way in Slim, and it wasn't that way in Skews. And there's nothing to suggest that an appellant has to persuade the appellate court that the judge has made an error of principle by reference to the Jane's principles.
It does look as if he's saying it's not capable, because if at paragraph 19, if an appellate court thinks that an article just does not bear that imputation.
Yes, and in fact, I see, if we go on to paragraph 23, he returns to the point that I mentioned, where it says that the allegation of being prepared to countenance a loophole in electoral law does not amount to an imputation of criminality. He was correct to say that the allegation of being prepared to countenance a loophole didn't amount to an imputation of criminality, but that the allegation of countenancing the funneling of money through a third party. Yes, all that is impermissible, he says, is to leap from the imputation of a crime of breach of electoral law to the imputation of personal criminal corruption.
Just dealing with the first point, my Lady Black's point, to say that it just does not bear that imputation, in my respectful submission, does not amount to saying that it's an incapable meaning, that it's utterly unreasonable. And to an impermissible leap in paragraph 23, again, that simply means that that's not a leap that I think the reader would draw. It doesn't mean that it's an utterly unreasonable way of looking at it. It doesn't mean that it hasn't applied the relevant principles.
Can we just go back to paragraph 20 in the citation from Slim?
Yes.
I think you submitted earlier that now that judges do these things and not juries, there's no proper basis for cross-applying or using in an appellate context the concept of available meaning.
Yes.
But doesn't it look as if Lord Justice Salmon is suggesting that may be an appropriate appellate approach, not least because that will enable the appellate court to look at the question as a matter of law? I'm just looking at the inset quotation halfway down page 396.
I think it's either he or Lord Justice Diplock who says in this case that it's only, whether a meaning is a capable meaning is just characterised as a question of law, but it's not really a question of law. I mean, there's no logical reason why whether a meaning is a capable meaning should be characterised as a question of law, and whether it is the right single meaning should be characterised as a question of fact.
Might it not be because, generally speaking, before one concludes that a meaning is not an available meaning, where a judge has found that it's the right meaning, you probably have got to identify some error of principle by the judge or departure from reasonableness?
Well, the single meaning rule proceeds on the basis that there may be a number of meanings which are not the product of an unreasonable construction, that readers could reasonably read the article in different ways. So that's the whole basis on which the rule proceeds. Then it also proceeds on the basis that there is one right meaning. So what's the benefit of asking whether the judge's meaning is a capable meaning? Simply so that you could characterise the issue as a question of law or a question of fact. I mean, the reality is the court needs to arrive at the correct single meaning as best it can. And now that, if the court takes a different view to the judge, that may be because he's done something which can be characterised as contrary to the Jane's principles, or it may be just because a different impression is formed. Because one proceeds on the basis that different people can interpret different ways. And these authorities support the proposition for which I contend that it's not necessary to show that the judge made an error of principle. It's sufficient simply that the appellate court arrives at a different conclusion. That's undoubtedly the case in the Skews case, where it's simply about impression and the way that an ordinary reader would be likely to understand the word. I mean, there's reference to reasonable grounds to suspect being more of a lawyer's way of looking at things than a layman's way of looking at things, but that doesn't necessarily mean that Miss Justice Brooke has made an error of principle. It just means that given you're supposed to reach the determination of the right meaning by reference to the way that a layman or layperson would look at it, Court of Appeal thinks a layperson would just look at it differently. I ask, why is it necessary why should it be necessary for an appellant to establish that a judge has made an error of law or an error of principle? In my submission, there's no reason to require an appellant to do that. It's sufficient that the appellant can persuade the court that his or her meaning is the right single meaning. There's no reason in principle to limit or to create a further exploration at the appeal court, which is the primary question of, has there been an error of law or an error of principle? If so, what's the correct meaning? One should just go to what's the correct meaning. And on a permission application, there has to be a real prospect of the appellate court reaching such a conclusion. So moving on to Bukowski, which, as I said, is in tab 10, volume 1 of the authorities bundle. It's at page 6 of the electronic bundle. Because of the time, I'm just going to go straight to the core passage from the judgment. It starts at paragraph 30, head of the standard of appellate review on meaning. I should just mention that this was a case where the Court of Appeal agreed with the trial judge. So this is obiter. There's a review of the authorities.
Why does the fact that he agreed with the trial judge make it obiter?
Because it wasn't relevant to wasn't part of the decision. He didn't have to grapple with the situation that the Court of Appeal disagreed with the trial judge, but had to work out the level of confidence that it was right and the judge was wrong. But if I'm wrong in it being obiter, so much the better, I suppose. In any event, we're in the Supreme Court now, so everything's up for grabs. The rival tests for the standard of appellate review are identified in paragraph 38, subparagraphs headed A and B. Taken from Duncan and Neal. B picks up on the quite satisfied. And then the conclusion of Lord Justice Simon is stated at paragraph 39. Which is, court should adopt a position somewhere between propositions A and B. He gives 3 reasons for acting with caution. Meaning's often a matter of impression. Experienced defamation judges are well practiced at applying the relevant test for determining meaning. And 3, plainly undesirable for the Court of Appeal to approach the issue on appeal simply on the basis they might have formed a different view to the judge.
What's wrong with that formulation? I mean, on your hypothesis, there's a right and a wrong answer to the question. If you're satisfied the judge is wrong, you intervene.
Yes.
What's wrong with the formulation?
Well,
you're careful before you decide that.
Yes, it doesn't really add anything. I mean, you have to be careful before you decide anything, and I mean, it's just potentially confusing. But
Well, it depends how you read the second sentence.
Yeah.
It should proceed cautiously before substituting its own views of meaning. Does that involve the premise that it has reached an own view on meaning and that it is different from the judge?
Well, it has to reach its own view on meaning in order to decide whether the judge was wrong.
Wrong or not, yes.
So the start point must be to form your own view on meaning, and then if it's different from the judge's view, what do you do? Are there circumstances when, notwithstanding you formed a different view from the judge, you don't interfere?
I think this is a number of the problem, isn't it?
Yes. And as I say, that's obviously quintessentially a problem for an appellate judge. But for all the reasons I've given, important.
But isn't that putting the cart before the horse? I mean, to say, well, I'm going to take a gut view whether he's right or wrong. I think he's wrong. Then I've got to climb through various hurdles before I can implement that gut view in terms of allowing the appeal. Surely the right way around to do it is to look very carefully at the judge's analysis and see if he went wrong somewhere in his analysis or in principle.
The start point is to look at the publication complained of, because that's what it's about. It's the right meaning.
Well, yes, you've probably got that in large letters in the front of your desk, but I mean, that's obviously the first thing to do.
Right. Well,
But just to jump from there to your own conclusion without actually seeing whether the judge has taken a wrong turning somewhere, which undermines his, isn't that perhaps the right way around to do it? I'm not saying that absolves you from having to make up your own mind.
One comes back to the single meaning rule. And what the judge is trying to do is to put himself in the position of the ordinary reader. You're not going to put yourself in the position of the ordinary reader reading the article for the first time if you read the judge's judgment first with all his reasons. You have to go straight to the publication complained of. Otherwise, any view that you take is going to be even further removed from that of the person who you're trying to replicate, which is the reader reading it in this way, in a casual fashion, and you're going to descend into over-elaborate analysis.
I think your answer to my Lord's question may be that it is, of course, appropriate and may be required of an appellate court in the first instance to examine the judge's reasoning to see whether he has, as my Lord has put it, taken a wrong turn. But even if you conclude that he hasn't taken a wrong turn as a matter of principle, you must still address the question, was his conclusion right?
Yes, I may respectfully agree with my Lord.
This court, in a panel of 7, wrestled with these problems about 3 years ago in a case called Re B. And I've been slightly surprised the authorities don't contain any of our decisions on review of questions of fact. There are quite a lot of them.
Yes.
The leading one's probably McGrady and Re B. And Re B is particularly relevant in the English context.
Yes, but it's the exercise that we're concerned with and the rights that are at play here, which I went through the 3 different types of appellate situation. One where it's been decisions based on credibility of witnesses, one where it's a multifactorial issue even though there's no credibility, and then this, which is purely putting yourself in the position of the ordinary reasonable reader, which are in exactly the same position as the trial judge. Looking at those 138 words that I took you to at the beginning of this appeal and asking yourself whether they convey the impression that the respondent was trying to kill the appellant when she used those words, trying to strangle. So if I have to take the position as stated by the Court of Appeal in Bukowski as the correct position, I will do so. And if you apply that to the facts of this case, the Court of Appeal did not approach it in this way. They approached it purely on a capability test and to look whether the judge had made an error of law. They didn't. They referred to not having a re-argument, that I was entitled to make the points that I made on domestic abuse before the judge, but I couldn't make them again in the Court of Appeal. That's not consistent with the way that the Court of Appeal is approaching the matter in Bukowski, that you've got to work out whether the judge has arrived at the right single, natural and ordinary meaning. So I say these formulations about act cautiously when satisfied, as satisfied as I can be, quite satisfied, don't give any practical guidance and are potentially confusing. The only matter is, did the judge reach the wrong conclusion? He might have done so because he made an error of principle, or simply because the Court of Appeal are of the view that its view or meaning is more likely to correlate with the majority of people who read the words complained of in their context. If I can just move on now to admissibility of material evidencing usage, which I'll have to deal with fairly briefly. It's at page 60 of the electronic bundle. It's tab D, paragraph 51 of my case. As I've said, there's authority for the proposition that you can't call witnesses to say how the words were understood. Gatley states that if the claimant relies on the natural and ordinary meaning, no evidence is admissible by the defendant or the claimant as to their meaning, but no authority is cited for this wider proposition. I think my learned friend accepts that there's no authority directly on point. In any event, it's open for this court to take its own view on this issue. Again, this is something that has come to the fore because we don't have a jury any longer. In reality, the jury was taken to constitute the ordinary reader. And in fact, having 12 ordinary members of the public is likely to lead to a consensus, more representing how the words were understood and avoid the possibility of an idiosyncratic interpretation.
But the jury may not be typical of the particular class to which the publication was made.
That's possible, yes. So I put this in as a matter of historical note. That may be a reason why this issue hasn't arisen, because you just wouldn't put material in front of a jury in this way. But whatever was done or not done in the past, one has to deal with the situation now. And in my submission, there's no reason why, in an appropriate case, a party shouldn't be able to put forward evidence of usage before the judge. And
But why does a judge... I'm sorry, I'm struggling here.
yes,
If you're pleading innuendo,
yes,
then obviously there has to be evidence.
yes,
If on the other hand, you're concerned simply with the ordinary and natural meaning of
Yes.
the words, why does a judge need the assistance of evidence?
why does he need a dictionary, one could ask? I mean, the same must apply to the use of a dictionary. And in fact, if you're going to a dictionary for a single word such as strangle, you're much better off looking for evidence of usage in relation to the words which are in issue, which are trying to strangle. In this case, it is of assistance. What happened here is that the judge went to the Oxford English Dictionary. Let's for the moment forget about what happened before. Let's just deal with the fact that he went to the Oxford English Dictionary at the start of the trial and said, this is the way I'm looking at it. Here are these two meanings. She's alive. She's got marks on her neck. Effectively, that must mean he was trying to kill her. Is it not open to a defendant in that situation to put forward material to show that you cannot make that logical jump? That's not how things work. This is a case where all the reasoning was based on the dictionary, and I was able to put before the court statutory provisions that plainly conflict with that interpretation. And CPS guidance. If we can just go briefly to the relevant material.
But frankly, I mean, the last way you're going to find out the ordinary and natural meaning of words is by looking at legislation. The logical conclusion is you ought to be leading evidence from the Facebook friends as to what
Yes.
they thought it meant, or alternatively from a random selection of members of the public as to how they would read it.
Yes. Well, but the judge has gone to the dictionary at the start of the trial, and he said, this drives us to this logical conclusion. He's not dealing with context. He's saying that is the only way this can be looked at. Why shouldn't the defendant go back and say, actually, that's not how the statutes approach it? They make a distinction between an attempt and an intent. So the specific two provisions, one that was repealed with the Criminal Justice Act 1967, but one which is still in force. There's CPS guidance that, when talking about available offences for strangling, talks about attempt to strangle. Surely that would, if you were the trial judge and you'd reached this conclusion, that would at least give you pause for thought, and you have to deal with it. You're the one person dealing with this matter, and you're approaching it in a very supposedly logical fashion. And here is statute which just flies in the face of your argument. Which it does. There's no question that the statute flies in the face of the argument that he's putting forward. Let's just start with the note that was filed. Now, I accept this was before the trial. I haven't got time to go into the chronology, but at the start of the trial, the judge said what he said in relation to dictionaries, and that was his conclusion at the end of the trial. And he had this material before him. So it's page 150 of the core volume and tab 6. Paragraph 4 refers to the CPS policy, and then turning over the page, footnotes to the offence in section 21 of the Offences Against the Persons Act. The CPS policy follows. You turn over the page to page 153. Second item from the bottom, examples of behaviour: choking, strangling, suffocation, possible offences, commonest or actual grievous bodily harm, attempting to choke, suffocate or strangle. So a behaviour of strangling can constitute the offence of attempting to choke, strangle or suffocate. The section 6 is, section 21 is on page 280 of the electronic bundle, volume 1 of the authorities, tab 4. You can see that the statute divides up the act, which is the attempt to choke. That's the first part of it, and then the next part is with intent. So the intent is separate from the attempt.
I really don't understand why you're relying. And I'm really just seeing where your submission takes us. You're looking, first of all, at a document drafted for the guidance of lawyers,
Yes.
the CPS, and secondly, at a Victorian legislation.
We're still in force, though.
So are parts of Magna Carta. If your argument is well-founded, why don't you simply lead evidence from members of the public as to how they would understand the words?
Well, that would be disproportionate. If I'm being too ambitious on this, let me simply deploy it as a defensive technique. Then, the judge, having relied on the dictionaries, and let's forget about chronology because in my submission it's not relevant. He started the trial by referring to the dictionaries. Then it was relevant to demonstrate that his logic was not correct, to draw attention to these statutes, which seem to suggest that the attempt was the act and the intent was the mental state. And that was the sole basis for his finding on meaning. And we have... that might be a more reliable guide to meaning than going to a dictionary, going to the CPS guide on prosecuting cases on domestic violence. And then there's the Greenwood case, which is absolutely explicit in terms of the distinction between an attempt to strangle and an intent to murder. I can move on now to the application of the appropriate test of appellate review to the facts of this case, approach of the Court of Appeal.
Can I just be clear what your submission is about admissibility?
Yes.
You're suggesting that it's admissible to, the two documents you've taken us to are admissible. What's the legal proposition?
Well, in a contract, I think there's authority. In a contract case, the court can go to anything which can assist it. My learned friend cites a case. It's a House of Lords decision. That's not a contract case, but it's, I think it's some sort of intellectual property case where there's reference to the court being able to refer to dictionaries or any other material which is easily to hand and can assist in the process, the determination that the court has to deal with. I think that I've cited from a contract textbook McNeil, that's tab 40, page 801. Paragraph 5124, there's a reference there, Mr. Justice Fry, not neglecting the use of dictionaries or any other means of information which may assist me in coming to a conclusion as to what is the ordinary meaning of the word.
Yeah.
can I ask the court to turn to page 66 of the bundle? This is my case. I set out the paragraph from the judgment of Lady Justice Sharp at paragraph 19, where she deals with the test on appellate review. She says the issue is not whether we would have come to the same or different conclusion had we been trying the case at first instance. In my submission, that is the issue, and that's the only issue, but even if it's not the only issue, it's a start issue. You have to ask whether you would have come to a different conclusion, and if you would have done, then you may be pausing for thought or reflecting, whatever, but that's a start point. That is not to usurp the judge's function, because the court's function is to arrive at the correct meaning. She then says it was open to Mr. Price to argue his points on context and domestic violence for the judge, as he did, but in my opinion, putting forward what amounts to a re-argument of the appellant's case on meaning does not assist him in this appeal. Well, of course it's got to be a re-argument, because you're trying to work out what the right meaning is. The judge referred and applied the correct principles of law. His reference to the dictionary, which was understandable in the circumstances, did not lead him into error, and in my decision, his meaning was one that was plainly open to him. So she's effectively applying a capability test. Wrong test. And of course, for the reasons that I've given, the decision wasn't open to him, over elaborate. He shouldn't have relied on the dictionaries in the way he did, and he didn't refer to context. And the dispute on meaning was clearly material to the outcome of the case, at least on the Court of Appeal's finding. I was going to address the court on why the justification defence must succeed, assuming I'm right on meaning and a lesser meaning is substituted for that found by the judge. I've got 15 minutes left. There are two parts to this. One is fairly straightforward, which is look at what the judge found and look at what was said. It's completely true, and if it's not completely true, it's clearly sufficiently true, such that any element of inaccuracy doesn't materially affect the claimant's reputation. And then there's a point about the way in which the respondent was allowed to depart from his pleaded case closing submissions, which does raise some points of principle. I've set it out fairly clearly in the case because I anticipated that it was the last thing I had to make submissions on, and time may be short, and that is how I've got a note here. 12:20, I should be starting on why the justification defence must succeed. I've already had half of that time. I'll just whiz through the case, if I may, making any further points that I feel it's necessary to make in the light of what's transpired thus far. So we're on page 67, paragraph 86. Two reasons are proved and admitted facts are plainly sufficient to justify the words complained of in their correct meaning, and then the point about the pleading. We've been through the words in paragraph 87. If you can just flick over again to the meanings on page 70, paragraph 102, had tried to kill the defendant by strangling her. Well, we just cross out the had tried to kill and act of strangulation for which he was arrested, had threatened the defendant and breached a non-molestation order protecting her, for which he was also arrested and has been arrested countless times, and accordingly it was to be inferred was a dangerous and thoroughly disreputable man. So let's deal with each of these elements. Tried to strangle me, that's clearly been proved if the meaning comes down. Threats, the judge did find that threats were made, although he didn't say there were any threats of immediate violence, but that's not what she said in those words, and that's not how it's pleaded in the particulars of claim. I've set out the threat that he made and was found by the judge. The judge accepts that he may well have boasted of threats, whether or not made to others, and his capacity to obtain details of the defendant's private affairs by covert means. So happens that these threats he's talking about are threats of violence against men who the respondent believed were in a relationship with the appellant. We've got the finding that the judge was obsessed by the appellant having relationships with other men. These threats were taking place in the context of the respondent wanting to pay her very little and her holding out for her entitlement, which he eventually agreed to. One of the grounds of the arrest was blackmail, And there was an express finding, and I rely on this particularly in the context of the threats, that his conduct belittled and intimidated the appellant, and the gravamen of a threat is its potential to intimidate. The non-molestation order, well, the judge found, as he must, that the respondent breached a non-molestation order, and he had a molestation order against him, and he breached it, which is what the appellant said, and that's the pleaded meaning as well. The respondent turned up at the appellant's market stall, and he got angry with her because she was with another man. The judge seemed to see that as a mitigating factor, which is strange, but in any event, what matters here is that he clearly turned up and he spoke about matters other than their son, and so breached the molestation order. The judge made a finding of breach just on the basis of him speaking about the son, but if you go to the references to the order, you can see it also prevented him from making direct contact with her, even to talk about the son. It had to be done through email. He couldn't just turn up where she was. The judge doesn't seem to recognise that, but it's clear from the order. In any event.
What's the page reference for the order, please?
For the
order.
Page reference for the order is it's set out in the re-amended defence. It's page 206. That's tab 10, paragraph 1413 of the defence. I think from memory what happened, there was a blanket order against contact which was varied to permit communications in relation to the son, but only by email or some other means. Page 206. Yes, it's paragraphs 1413 and paragraph 1414 of the defence, which were admitted in the reply, as they had to be, because just reciting what's in the order.
So all communication had to be by email, text or post?
Yes, so the variation was permit the claimant to communicate with the defendant via email, text or post in relation to issues relating to Joshua, but not to turn up at her market stall and start haranguing her about other matters. I mean, that's one of the reasons for having a restriction on mode of conduct in such orders. I mean, in my submission, the judge downplayed the seriousness of this. It doesn't really matter because it's not for my client to have to establish how serious it was. The words complained of referred to a breach, and that's what he did. In my submission, the arrests don't really add anything to the allegations that were there, but the fact was he was arrested on 3 occasions in relation to these matters. So how can the defence possibly fail if the meaning of try to strangle comes down from try to kill? So there was this element of dangerous that came into the equation. The judge felt the sting was that he was a dangerous man, but it's quite clear that what he regarded to be dangerous was heavily conditional on his finding that he tried to kill her. And he, in his judgment, on the paragraph of his judgment in relation to meaning, he says that understanding, in other words, the tried to kill understanding, would have informed the ordinary reader about the meaning of the remaining comments. So his approach to dangerousness is open to challenge just on the basis that it was premised on a false basis. And the word doesn't even appear in the exchange. It's an inferential meaning that's been advanced by the respondent, and it's extremely vague. What does it mean? It just means able or likely to cause harm. It's an imprecise word that refers to an unquantifiable risk of future harm. It's necessarily a matter of opinion. So are we going to be in a situation here where if a person who's been victim of domestic violence accurately states what's happened to her, she's got to just prove a general meaning that the respondent is dangerous when she hasn't said it? And he clearly is dangerous. I mean, a person can be a dangerous choice of partner without having been physically violent. It just means there's a risk of harm to the woman who's with him. I've referred to the non-statutory definition of domestic violence. But in any event, he was guilty of a serious and dangerous act of physical violence. The very fact that you put your hand around someone's neck with such force that you leave red marks there, it's inherently dangerous. You can kill people just by doing that. Certainly put them in the fear of death. It's a traumatic thing to do. And people who do it, who belittle and intimidate their partners, who are subject to non-molestation orders, let alone breach them, can be justifiably be described as dangerous. There's a sufficient but necessarily unquantifiable risk they behave in a similar manner with a future partner. And where the word isn't actually used by the defendant, it's merely an inference contended for by the claimant. We come back to Lord Devlin's warning in Lewis about it being almost impossible to give accurate information about anything. And then finally, in the 5 minutes I have left, this is the pleading point, which is significant because one has to accept, with a single meaning rule, the pleadings become very important. The meaning that the claimant chooses becomes important. It ties the defendant's hands in relation to the defences that can be raised. And if you go to paragraph 102, where I've set out the meanings pleaded, and the relevant one is paragraph 3, you can see that the dangerous is tied to the arrests. When this issue arose out of the blue in closing submissions, and the judge said it was ridiculous to tie it to the arrest, it didn't make any sense, the respondent's trial counsel said, oh, it was probably an error, that the pleader meant to hit another paragraph down so that it started, 6.4 started accordingly, it was to be inferred, so you were drawing the inference from the rest of it. I didn't at the time actually realise or think to go back to the defence, because this matter had been dealt with in the defence and in the reply, and it's quite obvious that this was a careful decision that was made. The claimant, for whatever reason, I've set out the relevant paragraphs of the defence in paragraph 104 of the case, where I put in issue the fact that it's reasonable to infer that someone is dangerous simply because they've been arrested. And then issue is joined with that in the reply, where there's a specific pleading to put that point in issue. So that was the battleground of the litigation on this issue. And I was satisfied, at least on this issue, that my point on meaning was a good point. And the judge agreed with me. He construed the meaning as being derived, dangerous meaning, from being derived from all the comments that were complained of, not just the fact of the arrest. But clearly that's not how 6.3 is drafted, which is fortified by the points made in the defence and the reply that I've taken you to. It required an application to amend. I rely on what was said by Lord Justice Salmon in Slim, that a plaintiff should be bound by any indirect or inferential meanings, otherwise it may prove nothing but a snare. Yes, the court can make up its own mind on meaning, but that depends when the determination takes place. Here we had a situation where the claimant didn't ask for a determination of meaning, and one was left at trial with the judge saying, I don't accept that 6.3 works as it's drafted, but in fact what's really going on here is the dangerous is tied to everything that was said, not just the arrests. In response to that, I raise a number of points, but the one on which I rely most strongly is I said that if the dangerous imputation had been freestanding, I would have considered an opinion defence. I didn't have to, because I was confident about the meaning point that I had on this. I also said I might have considered further evidence in relation to truth, because I did put in a meaning of dangerousness as a truth imputation, but I'd already pleaded a lengthy truth defence, so there was no difficulty in just adding a further paragraph. But in the situation where dangerous is extracted from the fact of the arrest and the judge regards it to be significant, of course I should have the option to advance an opinion defence if I wanted to, if he was going to allow the claimant to depart from what he had chosen quite clearly to plead. Dangerous is clearly an opinion. It's a value judgment, and both English law and the Strasbourg jurisprudence protects opinions which are wholly unreasonable, prejudiced, and exaggerated. You can see in the exchange that the defendant refers to her opinion, and her opinion possibly being biased. Doesn't matter if it's biased. It doesn't matter if it's a wrong opinion, insofar as an opinion can be wrong. There's clearly a sufficient factual basis for her to make that opinion, if indeed that is what the words were held to convey. And the consequence of the judge's approach was to visit on the appellant a judgment in defamation and an injunction against describing the respondent as dangerous. I'm just focusing on the dangerous element of this judgment. So part of the reason that he got damages was because he was dangerous, and the judge didn't think he was in fact dangerous. His approach required her to prove that the respondent was dangerous, and having failed to do so in the opinion of the judge, she found herself liable in damages and barred from ever saying that he is dangerous. That is a breach of, would be considered a breach of the Article 10 right, and in any event, would be susceptible to a defence of honest opinion, which I would have considered if the matter had been pleaded differently, and certainly if the judge had given me an opportunity when he chose to allow the respondent to depart from his pleaded case. Just excuse me one moment. Unless I can be of any further assistance, those are my submissions.
Thank you very much, Mr. Price. Mr. Barker.
Please, the court. To come back to the statements of facts and issues that my Lord Reid referred to, the key issue of principle in this case is the second question that's identified on page 46 of the bundle, or at tab D of the paper version, and that is, what is the correct standard of appellate review in relation to the judicial determination of meaning? That requires some consideration to determine what the correct appellate standard should be. Regard needs to go back to the nature of the exercise that's conducted at first instance. And it's, if I'm permitted, I'll just canter through some starting points in relation to the exercise in relation to the single meaning rule. The starting point, we say, is that the single meaning or the right meaning rule is a compromise solution based on what Lord Justice Diplock said in Slim is in one sense a highly artificial premise, namely that there is only one right meaning, which is the meaning that the words would have conveyed to the hypothetical reasonable reader, a phrase you will have come across time and time again in the authorities. Now, though any artificiality in the law might be thought undesirable, in this instance, to paraphrase Churchill's famous comment about democracy, the single meaning rule represents the least satisfactory solution to determining meaning and defamation claims.
I think you mean the least unsatisfactory.
Apart from all the other solutions that are on offer. And one just has to have in mind, if your lordships and my lady recall the quote from Lord Neuberger in the Hong Kong Oriental Daily case that's referred to in our skeleton argument, in our case, the alternative would be to have something perhaps approaching an extreme form of passing off action, where you'd have an endless parade of witnesses saying, well, I understood the words to mean this, and others saying, I understand the words to mean that. This is unsatisfactory, it is artificial to that degree, but it is a workable compromise.
One imagines it would, in practice, be easier to prove a case of defamation if you departed from the single meaning rule, because it would then be enough to show that some people would have read it in a defamatory sense.
Yes. And then you have the situation that sometimes arises in malicious falsehood cases, where it may be enough if some readers would have understood a particular meaning, because that would cause damage to the commercial activities of the prospective claimant. But it's important to remember that it's precisely because any given words may be capable of bearing different meanings to different readers, it doesn't follow that a reader who understands the words to bear a meaning other than the one that's found to be the right one is by definition unreasonable. Now, I think my Lord Briggs referred to the fact that, of course, it's meant to be an objective exercise in determining what the right meaning is to the hypothetical reasonable reader. But the determination inevitably involves an element of subjective impression on which different people, and thus different judges, might reasonably come to different conclusions. And indeed, the appellant recognises as much when one looks at paragraph 45 of her case, which is at 58 of the electronic bundle. And I won't go to it, but if it's easily, one can turn up, but I'll quote from it. What's said there is, it's implicit in the process that different tribunals of fact could arrive at different conclusions without contravening the principles. Now, recognition of that reality, we say, lies at the very heart of the compromise inherent in the single meaning rule, and should underpin an element of caution in the appellate approach when evaluating findings of the right meaning made by judges at first instance. And I'm grateful to my friend for going through all the authorities. Perhaps I can summarize the position as being this: the leitmotif that emerges from those authorities, perhaps starting back with Lord Justice Slim in that passage, Lord Justice Salmon in the Slim case, in that passage at page 186. The leitmotif is that while the judge's finding as to the right meaning is not sacrosanct, the appellate court will not likely interfere with it. Now, it's interesting to come back to Lord Justice Salmon's observations at page 186 of the judgment in Slim. There he observed the fact that an appellate tribunal, and of course one must remember this was back in 1968, it's Authorities Bundle 2, tab 25, one's looking at the paper, page 186
Thank you.
and following. And the observation there was, and of course context is important, because this is back in 1968 when capability was very much at the fore, as it was in the days when juries tried cases rather than judges, as is the case since the 2014 Act. So what Lord Justice Salmon is saying there is that while an appellate tribunal might traditionally in those days have approached the issue by considering as a matter of law whether the words were capable of bearing the meaning found by the judge, and if that were the case, that it was covered by capability.
186 must be the hard copy.
Yes.
I'm talking at the law report. Sorry,
It's
640.
somewhere after 617.
Grateful. 646 of
Thank you.
the bundle. I'm grateful. That's Authorities Bundle 2. I'm so sorry. I was going. As often happens with multiple pages, one sort of occasionally gets seduced back to the original report. So if one looks at 646, one has that starting at G at the bottom. No doubt, even when a libel action has been tried by a judge alone, an appellate tribunal may sometimes approach the case by considering as a matter of law whether the words complained of are capable of the defamatory meaning which they have been found to bear. If they are, the appellate tribunal will not likely interfere with the judge's finding of fact. If, however, the appellate tribunal is satisfied that the judge's finding of fact is wrong, it is its duty to reverse him. There is no sensible reason why a judge's finding of fact in a libel action should be more sacrosanct than in any other action. That raises a paradox to which my Lord Briggs referred, is that in cases in the old days where capability was settled and a range of meanings was left to be put to the jury, no complaint could be made to the Court of Appeal that the judge, having properly directed the jury as to the range of meanings available, the jury then chooses one of those meanings. It would not be possible to argue that the jury's finding of a particular meaning within that range was in any way perverse, so it would have been shut out. So there was a latent paradox, which is perhaps one of the problems one has with the fiction or the artifice at the heart of the single meaning rule, is whereas a judge could be the subject of an appeal, it would be very difficult for a jury, indeed I would say impossible for a jury to be appealed in its finding on meaning, provided that finding was one of the meanings within the range of meanings already adjudged to be capable. Now, such an approach, anchored in the concept of capability, will probably no longer be possible in future, because they've effectively been consigned to juridical history. The new normal, and we referred to this in the case, so I won't go over it. I refer to an example of a case in paragraph 9 of the case, a recent decision of Mr. Justice Nicklin in a case called Morgan. But the new normal is for meaning now to be determined as a preliminary issue at the earliest stage, even before service of the defence, and thus before the pleading of any substantive defences of truth or honest opinion which require a defendant to nail his colours to the mast on meaning. And this touches upon an exchange between my Lord Kerr and my learned friend. In the old days, the battle royal over meaning would often take place after the claimant has put in his particulars of claim with a very serious meaning, for instance, perhaps guilt of a crime, whereas a defendant would put in a fully pleaded defence of justification, seeking to justify a less serious meaning, suspicion of guilt, and that would be the battle royal. Now the approach is you don't get that far. You don't waste time putting in a defence. You determine meaning at the outset. And as my Lord Kerr said, it really doesn't matter what the meaning turns out to be and the repercussions for the defendant. One finds the meaning, and that is that. It is then for the defendant to decide whether, given the meaning found by the judge, it's possible for the defendant to plead a defence of justification or opinion to that meaning. So in future, the parties will know where they are from the outset. Now, paradoxically, the present claim, which was started in 2013, and before the coming into force of the new Act, the 2013 Act in January 2014, is something of a throwback on the capability front. Firstly, there was no determination of meaning at the outset. The defendant implicitly accepted, as is apparent from the defence at paragraph 6, that's at page 191 of the bundle, that the words were capable of bearing the meaning for which the claimant contended. Now, I'm not going to go back to it because one can follow this up later, but it's all dealt with in the cases. But there was no real dispute between the parties. There were arguments of nuance, but it was not argued in the defence by the defendant that the words were incapable of bearing the claimant's meaning. And so what happened is that the determination of the right meaning was left until trial, the rival contentions being between the claimant's pleaded meaning in paragraph 6 of the particulars of claim and the meaning which the defendant sought to justify, which is in paragraph 14 of the defence. And you'll recall that so far as the alleged strangling incident is concerned, that's contained in paragraph 14.1 of the defence. That's the violently gripping the throat with such force that the defendant was left in fear that she was going to die. In pausing, you'll recall also that paragraph 14.8 of the defence had the freestanding meaning of dangerousness, which, as we've said in our case, shoots down all these pleading points my learned friend has taken. It can't be said to have been caught by surprise, because from the very outset, he grabbed the bull by the horns and sought to justify the general meaning, the general imputation of dangerousness. But coming back to how this presented itself in the Court of Appeal, this was perhaps, in this case, the last time that a Court of Appeal found itself with a scenario of the kind envisaged by Lord Justice Salmon in Slim. Firstly, the judge effectively found the right meaning to be the one for which the claimant contended. Secondly, this was a meaning which the defendant ex hypothesi accepted was one which the words were capable of bearing, and thus one that was open to the judge to find as the right meaning. Yet now he says, my learned friend, and it's apparent from paragraph 2.3 of his case, which is at page 48 of the bundle, he says that the judge's conclusion on meaning was not open to him, but we say, well, it must have been at least open to him, because meaning was never challenged on the basis of incapability. Whether it was right or wrong is a separate question to which I'll return. So we say the proper analysis to look at how the Court of Appeal had treated the issue, while the judge's meaning wasn't sacrosanct, the Court of Appeal rightly treated it as one not to be interfered with lightly. So even though
because of the finding of the Court of Appeal that it was a capable meaning?
Well, it was I think it was taken as read by Lady Justice Sharp that it was capable, and hence why...
Was that which motivated the expression not to be interfered with lightly?
Well, that's the phrase that was used by Lord Justice Salmon back in 1968. But we say, as I'll come to develop, that we say that analysis, that leitmotif, remains appropriate. It's not to be lightly interfered with, and certainly not simply on the basis that the appellate court, starting from scratch, might take a completely different view of the meaning. But that was the scenario the Court of Appeal was presented with. Unusually, or as will now become unusual, at trial, the judge had two rival meanings put before him, both of which were conceded to be within the capable range, and he chose one of them.
Just before we go beyond that, you gave me page 191 as the cross-reference to where it became common ground that your alleged meaning was a capable or available meaning.
Yes, well, the reference, perhaps I ought to give you, 191
I've
is
just been looking at 191. I confess I haven't found it.
that may be my fault. 191 is the defence.
Yes, it is.
And it's tab 10 if one's using the paper version. And it's paragraph 6 of the
Yes.
defence. And if one goes to page 191, this is dealing with the meanings pleaded in paragraph 6 of the particulars of the claim. What said? It's admitted, save that in relation to 6.1, in the context of domestic violence, the words try to strangle do not impute intent to kill. They impute a gripping of the neck which inhibits breathing so as to put the woman in fear of possible killing.
So that, if read by defamation pleader, would constitute an admission that it was an available meaning.
Well, because the phrase that would be used by defamation pleader was, it would have been in the days when capability was challenged, it is denied that the said words bore or were understood to bear, or were capable of bearing the said or any other meaning pleaded.
But is that an appropriate way to plead now? That
Well, it won't be in the future.
dealing with juries?
No, it won't be. That will become obsolete because capability. There will be no circumstances in which capability will ever need to be addressed anymore. Precisely because the actual meaning, the right meaning, will be determined at a very early stage. And as I say, the new normal appears to be, I think one can say with certainty, that the new normal is it will be determined at the outset.
Is there anything in Lady Justice Sharp's judgment which indicates that she understood this to be a pleading which accepted that this meaning fell within the range of capable meanings?
I don't think expressly, I think it's fair to say she doesn't, but possibly that's the vice of a former defamation lawyer taking things as read, as everyone does. Capability was not an issue by the time of trial because the two rival meanings were before the judge. There was no argument that the words were incapable of bearing one or other meaning. The argument was as to which meaning the judge should plump for.
Well, what is it that you get in 611 which says implicitly that they accept that this is a capable meaning?
Well, it's not. What they're setting out is there's no plea that the words are incapable of bearing the meaning in 6.1. It joins issue. Say, well, it doesn't mean that.
So it comes with a qualified admission at the first line of paragraph 6, you say?
Yes. I mean, it's an admission. I mean, the curious thing is, paragraph 6 is admitted, save that. So what's being admitted? If one goes back to the particulars of claim in the previous tab, or if one's going electronically, it's page 183. The said words in their natural and ordinary meaning meant and were understood to mean that. So it's being, it's an odd thing to have an admission, but I don't want to get bogged down in the pleading point. But there was no attempt to raise a case that the words were simply incapable of bearing the meaning pleaded by the claimant. All that was being said is, well, it doesn't bear that meaning, and here's the reason why.
But Lady Justice Sharp does not seem to have taken it as an admission, because if you look at her paragraph 19, she says, in my opinion, his decision as to meaning was one that was plainly open to him.
Yes.
I mean, there may be all sorts of reasons why a party doesn't raise a meaning question as a preliminary issue. I mean, now after 2013, it may be because there's going to be a battle royal about whether real harm was caused.
Yes. Now, the unusual feature of this case is to have the issue of meaning left until the end of trial, which is the scenario that Lord Justice Salmon would have had, because back in the 60s, when the whole question of meaning would have been left until the very end, until the trial, whereas that will no longer be the case in future. Indeed, I think we can go as far as to say it's no longer the case now. It would simply not be allowed to plead a defence of justification to a lower truth, as it would be now, a defence of truth to a lower meaning, and allowed to trundle on towards trial in the hope that that meaning would be upheld.
Well, Mr. Barker, if I could put a rhetorical question, would that be a convenient
That would seem to be a
moment?
very convenient moment. I'm grateful.